Hi, I'm Jessica LaFour, Assistant Clinical Professor in the Legal Practice Program at the University of Michigan Law School. In this video, I'm going to talk about the sources of law and the court system. There are 4 primary sources of law, including the Constitution, statutes, regulations, and the common law. Each state has its own set of these laws, in addition to that of the federal government. Despite what you might remember from Schoolhouse Rock, that the legislature makes laws, that the executive enforces them, and that the judiciary evaluates them, actually all 3 branches of the government make law. The laws you are likely most familiar with are those that the legislature makes, what are called statutory laws. Statutes are laws that are passed by the legislature and signed into the law by the executive branch. Statutes are often collected in books called code books. Michigan has a criminal code, and the U.S. Code houses many federal statutes. One type of law that you will encounter this year that is always statutory is criminal law. Criminal offenses are always laws that are passed by legislatures and captured in these code books. But the executive branch also sometimes makes law. One example is regulation. A regulation is a rule that is made by an agency of the government, like the agencies that are part of the Department of Justice, as seen here. Why are regulations made? Well, sometimes the legislature passes a law that doesn't really explain exactly how the law should be carried out or enforced. That might be because drafting a vaguer law made it easier to pass, or because the legislature doesn't have the expertise to think of all potential concerns. The legislature will then delegate in the statute the responsibility for filling in those gaps to the agency in charge of carrying out the law. For example, Congress has passed a statute providing that a prisoner is to be released upon the expiration of their sentence. But Congress also gave a specific agency, in this case the Bureau of Prisons, the ability to create regulations to enforce that statute. The Bureau of Prisons created a regulation that states if the release date should fall on the weekend or a holiday, the release of the prisoner would be allowed the week before. When a party is entitled to, but isn't afforded, the right provided by a regulation, they sometimes have the right to go to court, just as with a law passed by Congress. So long as regulations aren't inconsistent with the underlying statute, and don't go beyond the authority that Congress gave the agency, a regulation will generally stand with the force of law. Lastly, the judiciary also creates law by interpreting the Constitution and statutes, and by creating what is known as the common law. First, the court evaluates and interprets the Constitution and statutes. As I said before, sometimes statutes, and certainly the Constitution, are not written as clearly as they could be, and parties have different interpretations of what the law means, which courts then must resolve. The court is responsible for determining which interpretation is the best one. But, in addition to interpreting these written laws, the court also develops and applies what is known as the common law. The common law is a body of law that originated in England and was adopted and modified by the states and the federal government. As a result, it lives outside statutory law, and is instead derived from custom and judicial decisions rather than a legislature's action. Because the common law exists outside of statute, you can't see the common law in a code book. Instead, lawyers figure out the common law by piecing together judicial decisions. 3 prominent areas of the common law include property, contract, and torts, 2 of which, contract and torts, you'll be learning more about this year. Let me give you one quick example of this difference between these 2 areas of law that you'll encounter this year. In Michigan, there is a crime of assault, and the elements of that crime, or the criteria for proving it, you can find in the Michigan Criminal Code. You'll also find judicial decisions interpreting those elements and what does or does not meet them. However, there is also a common law tort of assault. Someone can sue someone else for assault. The elements of this tort may or may not exactly align with the elements of the criminal offense. So, to figure out what constitutes the tort of assault, you'll have to piece together a number of judicial decisions written over the years on the subject, but you cannot rely on the criminal statute or the decisions interpreting that statute. Importantly, most of the common law in the United States is state law. There are only very limited areas of federal common law. For example, there is no federal tort of assault. The court system. Let's turn now and look at the court system. Just like how the federal and state governments make separate laws, they also have separate court systems. And that's well illustrated here by this map of Ann Arbor. The red arrow indicates the federal courthouse, and the green arrow, the state courthouse. In case you're wondering, the blue arrow points in the direction of the law school. Separate systems, separate cases, separate courthouses. So how does a case originate in federal court versus state court? In answering this question, we're going to talk here specifically about civil cases as opposed to criminal cases. Criminal cases proceed through the court system in a different way. For civil cases, federal court is what is known as a court of limited jurisdiction. And civil cases are appropriately heard in federal court in only two circumstances. The first is if the case involves a federal question, meaning a question about the interpretation of federal law, for example, the Constitution or a federal statute. The second is if the litigants, or the parties to the case, have what is known as diversity jurisdiction. To have diversity jurisdiction, the parties must be from different states, and the amount of damage alleged in the case must exceed a certain monetary amount set by statute. Unlike in federal question cases, in diversity jurisdiction cases, it doesn't matter if the underlying legal issue in the case is federal or state. The federal court can still have jurisdiction. So, what originates in state court? Well, pretty much everything else. State courts are courts of general jurisdiction, which means they don't have the same restrictions to hear cases as federal courts do. They can hear cases even by parties of the same state, and regularly do, and can sometimes hear cases that have federal law issues, so long as the case also has a state law issue. This is in addition to hearing state criminal cases. As a result, state courts hear by far the most cases of the two systems. Now let's look at the basic structure of the court system. Here, we're going to look at the federal court system because, while many states follow this structure, some do not. And we'll talk about some of those differences in a minute. The federal system has 3 layers: a single Supreme Court at the top, 13 intermediate-level appellate courts, and 94 trial courts. At the bottom of the structure are the trial courts, which are called district courts in the federal system. There's at least one district court in every state, and sometimes more. However, the district court boundaries never cross state lines. As you can see by the graph here, Michigan has 2 district courts, the Western District of Michigan and the Eastern District of Michigan. The district courts represent the starting point for most federal cases. If litigants are unhappy with the decision of the district court, they have the right to appeal. Those appeals are heard at the federal appellate courts, called circuit courts. There are 12 regional circuit courts, and they're referred to by number, like the First Circuit, the Second Circuit, and so on. And you can see some of those numbers here on the screen. So if a litigant in one of the district courts of Michigan wants to appeal their case, their appeal would be heard by the Sixth Circuit, which is also the Court of Appeals for the district's courts in Ohio, Kentucky, and Tennessee. But wait, Jessica, you said there were 13 appellate courts. Yes, the 13th appellate court is the Court of Appeals for the Federal Circuit, located in D.C. That court hears cases from all over the United States, but only in specialized areas of law, such as patent law. The top of the pyramid, of course, is the Supreme Court. Unlike appeals to the circuit courts, which litigants always have the right to ask for, appeals to the Supreme Court are only by what is known as a writ of certiorari, or cert as you'll most commonly hear. That means that the Supreme Court has the discretion to choose which cases it will hear. And it only hears about 75 cases of the more than 10,000 requests that it receives every year. The Supreme Court also has what is known as original jurisdiction, meaning some cases start in the Supreme Court. However, this happens in just a few circumstances. For example, if a state is suing another state. So, most cases come to the Supreme Court from the circuit courts we just discussed. However, it is also possible for a litigant whose case has been heard in a state Supreme Court to then appeal to the U.S. Supreme Court. This happens only if the case raises a substantial federal legal issue. As I said earlier, the court structure of many state courts looks just like the court structure of the federal courts, and Illinois is a good example of that. It has trial courts, multiple appellate courts geographically divided, and a singular Supreme Court. Other states, however, like Michigan, have only one single court of appeals, a single intermediate level appellate court to which all trial court cases go, and then a Supreme Court. 10 states, including Nevada as seen here, have no intermediate appellate level courts. That means there's only a trial court and the Supreme Court. Texas, on the other hand, has 2 Supreme Courts, one for civil cases and one that's reserved only for criminal appeals. Though the structure look a little bit different among the states, there's still hierarchies, and that is critical to know. Finally, most states have additional courts of limited jurisdiction, specialty courts, such as probate, which deal with what happens with people's property after they die, and small claims, in which unrepresented people can bring cases involving small amounts of money. There are a few other differences between the federal court system and some of the state court systems. One of the most critical is the name of the courts. In the federal court system, the term circuit court refers to that intermediate level appellate court. However, in Florida, and actually in many states, the name circuit court refers to their trial court. And in New York, the trial court is actually named the Supreme Court, whereas the highest court is confusingly called the New York Appellate Court. So, when you are reading cases, it is important to understand that the names of the courts don't always tell you which level of court you're in. In sum, understanding the places that laws can originate and understanding the structure of the court system are both critical to understanding how courts make their decisions. And that will be the focus of the next segment.